All right, back to our mailbag. This person was made redundant as a result of a merger and let go without cause or notice and told it was not performance related. The owner of the company they were merging with was taking over the position as part of the merger. When they let go, they said he would be receiving a package. When the last pay had an additional 2 weeks payment, and he thought that was vacation pay. He inquired about the severance package and told that was it. So that's the extent of his severance. This person was in his 50s. He worked at that place for just shy of 3 years, and was wondering what he thought he should. On some research, he thought he should get 4 to 6 months of compensation. Did not receive a termination letter, had not signed anything, but was worried about trying to take some legal action due to costs. He feels that he was not treated fairly. He sent a letter to his former employer expressing his concerns, but he thinks they're just trying to get away with as little as possible. And he's wondering what this person should do next, and if his former employer isn't going to resolve this in good faith.
All right, so let's define wrongful dismissal. A wrongful dismissal basically means you were terminated without any notice or pay in place of notice. And in this case, we're talking about a termination without misconduct. So this individual was entitled to either working notice of that termination or what most people refer to as severance in place of that termination. And you got to look in a few different places. Number one is you have to look at the legislation. So he says he's worked for less than 3 years, so he's going to be entitled to a basic payment by law, which is mandatory and unconditional, and it needs to be paid to him, and it's illegal if they didn't pay it to him. He says he got 2 weeks, but it was just vacation pay, in which case he hasn't been paid the statutory minimum is illegal. And the employer could certainly be dinged with additional damages as a result of that, especially if they knew that they were doing it. The second thing is that the courts have said that the basic minimum that you're owed under the legislation isn't quite enough for some people. So for individuals who are older in age, who worked for a little bit longer, who have more senior positions, they're clearly entitled to an additional payment on top of the statutory amount that's guaranteed to you under the legislation. That additional payment is debatable, not the fact that it has to be made, but how much it is. So it's something you have to look at the analysis of what the courts would look at to determine what he's entitled to. He thinks he's entitled to 1 month per year. That's a rule of thumb approach that's been ruled out by the courts and isn't really applied anymore. So you have an individual that's 52. He says he was the general manager, which is a senior position. He's been there for less than 3 months, and he's talking about 4 to 6 months of compensation. I think that's in the range, probably at the top end of it, though. I would say somewhere between 3 to 6 months of compensation, and he needs to understand, as everyone does, that doesn't necessarily mean that the employer has to cut you a check for 6 months' pay. They have to indemnify your losses for up to 6 months. So what it means is if he found another job after the 3-month mark that paid him approximately equivalent to what he earned with the taxi company, they would really only have to pay him until he resituated another job that paid him a comparable income, because after that point in time his losses are nil. So in this case, he does have a case, and it certainly looks like they owe him some more money, and he's asked about what he should do. He tried to resolve it on his own, and it didn't get anywhere. Now, I don't know what his compensation is, but let's just assume, well, let's put it this way. He can file a small claims court complaint, and in Ontario, at least, the maximum jurisdiction for a case like that is $25,000. So if he's worried about lawyers' fees, he can go to small claims court, because you don't need to have a lawyer to do the case, even though I think it should be recommended if it's anything more than a very simple case. And I don't know how much he made, so it's hard for me to say whether or not he should be fitting within that jurisdiction. Anything outside of that, you would go to regular court, and you would need a lawyer to do that. Another avenue he has is you could go to a provincial Ministry of Labour and make a complaint for the Employment Standards Act payments that they owe him. In this case, it would just be 2 weeks. And it would be a mistake for him, if he's in Ontario, to go to the Ministry of Labour here, because once you file a severance complaint at the Provincial Ministry of Labour, you are barred from filing a wrongful dismissal complaint in the courts. And as I just explained, what he's entitled to is in excess of the statutory amount. So he would be in some trouble if he tried to file a statutory complaint for his 2 weeks, because then he would be prevented from getting anything else on top of that in the courts, and he's clearly owed more. So in summary, he's got a good case, and I don't know how much he made, but sometimes you have to spend some money to make some money.
Mm-hmm.
And he seems pretty afraid to talk to a lawyer, but he does have a case here, and I think most people would tell him there's a way to make it work with a lawyer if he's got good facts like he does. So he definitely has something there to work with.
Right. Okay. Let's head on to the next one. This one is also about severance. This person's wife was let go from work for poor performance. Said there may have been 1 or 2 occasions where she misspoke over the phone over the last 5 years of her tenure. Now, and currently, his wife is pregnant and scheduled to have a baby in July. The severance package that was offered, they find it's not sufficient because this, of course, she won't be able to find a job for another 16 months due to the child, and there were no benefits included during that time. And this would leave them in a very difficult place. And they were wondering what to do.
Okay, well, serious issues we're talking about here. So the first thing is the situation is that the individual was laid off or fired for poor performance, and I just want to distinguish where that fits into the big scheme of things. So you can be fired for misconduct, and if you're fired for misconduct, you're not entitled to any severance whatsoever. Okay, the employer has to prove that there was some form of misconduct, but it's important people understand we're talking about the most serious forms of misconduct here. So theft, dishonesty, breach of trust, willful disobedience, really serious stuff like workplace murder, basically. And anything outside of that is not sufficient to deny paying someone severance or giving them notice of the termination. So poor performance, for the most part, is not considered cause for dismissal. In 9 out of 10 cases, judges will find that it's too subjective, and I'm not going to find this person's level of alleged poor performance satisfactory to avoid paying any severance. So the way I would approach this is that we're talking about what should be a termination without cause for someone who's already pregnant. And the first thing you have to explore is whether or not the pregnancy played any role in the decision to terminate, because if it did, then it's illegal, and you could seek additional or sue for additional damages. The next thing you'd want to look at is how does the fact of being pregnant at all, how does that affect the entitlement to severance? And the court cases out there and the case laws basically said that it renders this individual it puts this individual in a position that makes it more difficult for them to reemploy, as a result of which they should get a bump up, an increase in the amount of severance that they otherwise would have received. And there was a case I'm familiar with a couple of years ago where an individual who was fired when she was 5 months pregnant got an extra 2 months pay from a judge as a result of simply she wasn't being discriminated against, but she was pregnant, which made it more difficult for her to find other work. So it definitely impacts the assessment of severance. And I'm familiar with literally over 50 factors that courts can look at in assessing what should increase the amount of severance or decrease it. And being pregnant is certainly one of them that would have a high impact on that. And then the third thing I wanted to mention was that she said that her benefits were not being continued, and that's obviously a big deal because she's pregnant. Number one is that when you're terminated, the employment legislation mandates the continuance of benefits for a certain period of time, and that period of time is consistent with the statutory period of termination that's outlined in the legislation, which depends on how long you've worked for. So the benefits absolutely have to be continued for that period of time, and the courts also require the employer to continue the benefits during the common law, which is that greater period of severance on top of the statutory period. So the fact that they haven't offered to continue her benefits is definitely problematic as well.
Right. Now, do employers need to tread very carefully when you've got someone in your midst who's pregnant and then you may be doing some changes to your workforce? What do you need to keep in mind?
Yeah, you need to keep in mind that first you need to know what the law says, and the law says basically if someone's off on a maternity leave of absence, they're basically guaranteed their job back unless you can show that their termination was for reasons unrelated to the leave. So what employers need to do is, number one, is they need to be able to show that terminating an individual who's pregnant or is off on leave is for reasons unrelated to that. And it's really only in exceptional circumstances that should occur. So if a division of a plant is shut down and someone is part of that division, the employer doesn't have to reinstate her. And obviously, if half of the workforce was laid off, it's going to be difficult for an individual to show that her particular case, her termination was related to her being pregnant. So, for employers, I usually ask when they tell me, look, I've got to let someone go, is this a situation that we need to be more cautious about? Yeah, certainly you do. You need to ask why this individual is being terminated. Is it because of this person has an intention to take leave of absence, or is on the leave of absence because there are special rules around that? And the other thing is that you don't want to template them into your severance offers. So, what employers will do when you lay off a number of people is they'll say that we can't really treat anyone differently. We've got an analysis that says we're going to look at everyone's position, age, and years of service, and enter that information into our severance calculator. Is going to spit out a calculation for us. And what I tell them is, I think that's a bad idea. I think it's a bad idea because you have to look at people's personal circumstances. So, if you have someone who has a disability, that is a personal circumstance that would make it more difficult for him or her to find other work. And that should be factored into the severance assessment, just the same way it would be if you have an individual who's pregnant. So I really think you need to personalize the severance obligations, and you need to make sure that you know who you're dealing with instead of simply looking at a very formulaic calculation for it.
Now, is there also a problem you can run into just on the other side? Let's say you are laying off some people, and you, in particular, to make sure you're not running into any problems with the law, you keep someone on who's pregnant, let's say. Do you run the risk of the other employees seeing that and coming after you in some way, saying that you gave someone else preferential treatment?
Well, they can't really look at what another employee got and say that somehow would affect their own severance entitlement or their own situation. I mean, I think what you're suggesting is there almost like an affirmative action for someone who's pregnant, and the company treats her better. Is that unfair to the other employees who lost their jobs? It may be, but really their only cause of action is to argue that the severance that they received was unsatisfactory. And what other people got from the employer is generally off the record and can't be used as some sort of a litmus test of what they should receive. What they need to do is they need to argue based on their own personal circumstances and based on published court jurisprudence to establish that the deals that they got weren't satisfactory.
Right. Okay. On to the next one. This one's a little shorter. This one says, can I sue my employer, boss, or coworkers personally for any abusive, harassing, discriminatory, negligent treatment of me, as well as professionally, as employees of the organization? So can you basically take some harassment suit against not just your company, but the employees personally?
Short answer is yes, you can. And where you see this a lot, more so in civil actions, you see it a lot, more than civil actions, you see it a lot in human rights complaints. And what people do is, as part of their human rights complaint, they'll name not just the company, but they'll name the boss or the individual or the manager that was responsible for the alleged form of discrimination. So you can make them part of your human rights complaint. You can do the same thing in a lawsuit. If someone has stepped outside of their duties as your supervisor and has done something in a personal form of harassment or assault, for example, absolutely you can sue that individual personally, and you can sue the company, making them vicariously responsible as well. So it happens quite often.
Is that more complex, though, in that sense? What do you have to prove if someone, it's not just the company at fault?
It does make it more complex. You have to demonstrate that the individual was acting outside of the scope of their employment. And that's basically the test that's used to render someone personally responsible for the action. So, if I'm performance managing you, Jillian, and you take the position that I'm bullying you, and it's because you're a female and I'm harassing you, you would basically have to establish that if you proved harassment, number one, that the actions I took towards you were outside of my job as being your manager, in order for me to be personally responsible. And it's a heightened test. And the reason it's a heightened test is because the courts in Canada, they would prefer not to have they would prefer to have less of these types of complaints than more of them. So they make it a little bit more difficult in terms of setting the standards to sue individuals personally. Usually the employer's put on the hook. Right.
Okay, we have a new question from the email. It says this person wonders if an employee on maternity leave is required to disclose the date of their return to work in advance to the employer. And if they are not required to give notice ahead of time, are they required to give any notice any notice at all, or can they simply walk in the door one day and expect to go back to work?
Okay, so a simple
I'm
answer.
feeling this may be coming from an employer.
An employee. It could be.
I'm not sure.
Could be. So here's the simple answer. Okay, number one is if we have a federal or provincially regulated employer, you have to check the federal legislation or the provincial legislation because it's different in each jurisdiction. So what you do is you go online, you go to Google, and you type in, if you're in Ontario Ministry of Labour Employment Standards Act, and there's going to be an easy-to-interpret guide that will explain the maternity leave reinstatement obligations for employers and employees. The basic answer is, yeah, employees have to give, in Ontario, 4 weeks advance notice of their return while they're off on work, and that's how it works. So whoever's looking for the answer to this question, it's something that's basically black and white in the legislation. You just need to find the right piece of legislation and read it.
Right. Now, is it similar in all provinces?
It's different. Every act has similarities, but some differences too. So I can't off the top of my head tell you what every single jurisdiction in Canada says, but for the most part, there is a period of time that an individual who's off on maternity leave has to give an advance warning of their return. Right.
Now, is that then guaranteed that they get back to the exact same position, or is that more the case that's when you have a chat with your boss or your HR department about what you're coming back to?
So the intention of the legislation in these cases is that individuals, number one, are supposed to be reinstated, period. And it's a heavy obligation to get outside of that reinstatement right, and it can only happen in certain circumstances. What the acts specifically say is they say that you have the right of reinstatement to the job you held while you went off work, or to a comparable job if your own job doesn't exist. So first thing is, excuse me, is does your own job exist? And if it does, you have to get it back. So you can't be asked to come back to somebody else's job if your job is still sitting there. You're basically going to get the job that you had back unless there is some very compelling, exceptional circumstance. And then you have to consider is if your job doesn't exist, is there a comparable one, and is that job comparable? So comparable in all respects. Is the salary the same? Are the benefits the same? Are the responsibilities the same? Is the location the same? And is the seniority and status the same? And if anything's been changed substantially, it's essentially a violation of the labor and employment standards legislation.
Now, are employers held fairly high in when it comes to maternity cases like this? Are courts fairly strict on them on following these to the rule?
Absolutely, they are. Absolutely, they are. But you see, the problem is you have to get to court or to a labor tribunal adjudicator in order to sometimes enforce the right that you have. And I have a personal problem with this because the intention of the legislation essentially is that only in very exceptional cases should someone be terminated and not given reinstatements to the job they had or a comparable one at the end of the leave. So it really should only be in very, very limited circumstances. But a lot of employers have really used the existence of that exception, the exception being you don't have to reinstate if that reason is unrelated to the leave of absence. And it really was only supposed to be a very narrow exception, but it's kind of been blown open. And I see a lot of employers trying to fit into that exception situations that really shouldn't be there. And if you ask me, are courts and labor adjudicators more difficult to employers in those circumstances? Certainly they are. It's a very high standard. It's an employee-friendly test, and it's an employee-friendly jurisdiction. Canada is when it comes to assessing cases about maternity leave termination, discrimination, things like that. So certainly the employer needs to understand that there's an elevated or heightened onus on them to do it right and get it right. And what I mean by get it right is to comply with the law.
Right. Okay. On to the next one. Okay, this is a person who has been given a severance package offer that includes biweekly salary on a continuance basis, but this person has made a request for a lump sum payment. The employer's response, though, was that they were not obligated to pay the severance in a lump sum payment, and so you'll continue to get your salary. Now, does this violate, in particular, I guess this is the Employment Standards Act 2000, does it violate the Employment Standards Act is the question here.
Okay, so this is a very fact-specific, jurisdiction-specific question. And because they've asked about the Ontario legislation, I know we have Canadian viewers, it's different in every province. The Ontario legislation does say that if you are entitled to severance pay, which is you've been there for more than 5 years and your employer's payroll in Ontario is more than 2.5 million, that you have the right to receive the severance pay in a lump sum. So the employer would be wrong there, and you have the right to demand it, and they would have to basically compelled to pay it to you that way. The provinces across Canada are very similar, but not all of them have that specific statement in the legislation that basically compels the employer to pay it as a lump sum. So it's very specific upon where this person lives and the jurisdiction's legislation.
Where's the best place for this person to look for that information?
Well, this individual is from Ontario, so again, you go online, you type Ministry of Labour, and the Employment Standards Act comes up, and you can also call the Ministry of Labour because they have a hotline. In fact, all of the ministries of Labour provincially and even the federal ones have a hotline where you can call and speak to a representative to give you information. I call from time to time when I have questions for some of my clients. I'll call and talk to an expert there who can lead me to the right provision of the act. I mean, sometimes it's not as easy as that. You really have to look at some of the jurisprudence under the legislation. But a question like this, I know there's an answer, which is it says it in the legislation. So I think it's a good idea to call and speak to someone live, or just do some research online and see if you can find the part of the act that has the answer to what you're looking for.
Right.